I'd like to welcome everyone to this, the third event of the Constitutional Law Center this academic year. And this is an annual event that we put on, a Supreme Court Roundup, in which we bring in some of the leading appellate advocates and Supreme Court advocates in the country and talk about what the court did last year, what the court is doing this coming year, and mix it up a bit. And so this year we have as our guests two very familiar faces to almost everyone in the crowd here, Jeff Fisher and Pam Carlin, my colleagues here at the law school, and the two of the three heads of our extraordinarily distinguished and successful Supreme Court clinic. I don't even know how many Supreme Court arguments they have made between them, but it's a pretty high number. And then to welcome also a guest, Allison Ho, who's speaking to us from Texas and is the co-chair of the Appellate and Constitutional Law Group at one of the nation's leading appellate law firms, Gibson, Dunn and Crutcher. And again, I couldn't even count her Supreme Court arguments either, but her website says that she has had over 60 appellate arguments in the various courts, and many of them are ones that all of you would have heard from. But that's enough from me. Let me turn it over to them to tell us about last year and next year. As they're speaking, please think of, and now speaking to the audience, please think about questions and either hold them, or you could email them in the chat, send them in the chat function, and Chaz will be more than happy to keep them so that at the end of the talks, the speakers can address those questions. So take it away, Allison, Jeff, and Pam.
Thank you so much. It is an honor to be the honorary Texan, I guess, on this just esteemed panel. It's just such a privilege to be speaking with y'all today with these just amazing advocates. So I'm going to start us off by talking about one of the most notable things about this past term, which is the degree to which it was the Chief Justice's term. He was in the majority for 10 of the 11 5-4 decisions, and he was in the majority of 51 of the 53 signed opinions. He was in dissent only 2 times, once in the Oklahoma Indian law case and in Ramos versus Louisiana, the Ministerial requirement case. I think you can really appreciate the influence of the Chief Justice this term in a trio of blockbuster cases, the Docket case and the 2 presidential subpoena cases. In the Docket case, which I'm sure many of you are familiar with, the DHS versus the Regents of the University of California, the Supreme Court set aside DHS's decision to terminate the DACA program, which allows some individuals with unlawful presence in the United States after being brought to the country as children to receive renewable 2-year periods of deferred action for deportation and to be eligible for work permits. The Supreme Court held that DHS's decision to rescind the program, first of all, it held that that decision was judicially reviewable. And second, it held, reviewing it under the Administrative Procedure Act, that it violated the act because it was arbitrary and capricious. And the case was argued by my firm's own Ted Olson. And the court, 2 important holdings from the case. As I mentioned, the court first held that DACA, the decision to rescind the program was judicially reviewable because DACA created a program that bestowed affirmative immigration benefits. The court then held that that the rescission of DACA violated the APA because DHS didn't adequately consider the alternatives or address rescission's impact on reliance interests. So you have this case of immense importance from a purely human standpoint. The hundreds of thousands of DACA recipients throughout the country. And yet it turns on what I think to many would be sort of an arcane technical area of the law. And I think the challengers did a really brilliant job of marrying up the human impact and the human face of the case and what was at stake in terms of lives and livelihoods, marrying that up with a strategy of focusing on the administrative, technical aspects of the case that I think was especially effective at persuading the Chief Justice. And I think the Chief Justice in his majority opinion summed up this duality well when he wrote, "When so much is at stake, the government should turn square corners in dealing with the people." I think that's a theme that reverberates through much of the court's recent administrative law cases, that especially when the consequences of regulatory action have a great impact on people's lives and livelihoods, that the government can't cut corners when it comes to the regulatory process. And note that the decision didn't say that DHS couldn't rescind DACA, only that it didn't go about doing it in the right way. So as important and consequential and impactful as the court's decision was for the DACA recipients themselves and their families and their loved ones on a human level, it's also an important decision going forward in terms of this proposition that where a lot is at stake, and given the extent of regulation, that's not going to be a small set of cases, I don't think, that where a lot is at stake, the government has to follow the rules set out in the APA scrupulously. The next two blockbuster cases where the chief wrote the opinions are the presidential subpoena cases, and they're also focused on proper procedure and decision-making. At issue were President Trump's financial records, in one case, subpoenas from congressional committees, and in the other case, subpoenas from a New York State grand jury. Sort of taking the more high-profile battle with Congress first, it presented unprecedented issues for the court, which had never before addressed a congressional subpoena for a president's personal information. The court sought a middle ground, and it found one on a broad 7-2 vote. On one hand, the court was sensitive to the separation of powers concerns that arise when Congress seeks personal papers from the sitting president. On the other hand, the court rejected the president's broadest assertions of absolute immunity and left the ultimate question of whether or not the documents had to be turned over to subsequent litigation. The president had asserted that separation of powers concerns required Congress to show a demonstrated specific need, and it's a quote from United States versus Nixon, to subpoena the records. The committees failed to show that, the president argued, and lacked the legitimate legislative purpose necessary to justify the subpoenas. The Chief Justice's majority opinion first rejected the categorical approach of applying Nixon, pointing out that the records at issue in this case, unlike in Nixon, didn't implicate executive privilege. But the majority also rejected the approach recommended by Congress, describing it as essentially limitless. So to thread the needle, the majority outlined 4 special considerations to help courts balance Congress's significant legislative interests against what the court referred to as the unique position of the president. And the court remanded the case for further proceedings in light of these considerations. So turning to the case involving the New York grand jury subpoenas, the court rejected the president's assertion in that case of absolute immunity from state criminal process. And in an opinion for 5 justices, the Chief Justice noted the long history of presidents complying with federal subpoenas in criminal matters and concluded that state court subpoenas were not all that different. He rejected the contention that some kind of heightened showing of need is appropriate where the president is the subject of a subpoena. and he remanded the case for whatever further proceedings might be necessary. Two other justices, the newest members of the court, Justices Kavanaugh and Gorsuch, concurred in the judgment, but would have applied a heightened need test for state subpoenas for presidential material. And two other justices, Justices Alito and Thomas, while also rejecting absolute immunity, dissented on theories that the court owed the president more deference than it showed. And I think it's interesting that in none of these opinions by the chief, the two subpoena cases and the Docket case, is the Supreme Court's ruling the final chapter in the story. And all of them share the same concern with procedure, with proper decision-making in DACA, the executive branch, and in the subpoena cases, the courts. While some commentators have characterized these decisions as sort of the split the baby variety, to me, I think it's more accurate to see them as examples of an approach that the chief has long held and espoused, which is, as he says, when it's not necessary to decide more, it's necessary not to decide more.
Allison, can I ask you one quick follow-up? I'm really interested in your take on the theme of the Chief Justice's influence, which is obviously such a big theme from last term.
Yes.
And, you know, as we look ahead, many people are asking, now that we have a vacancy on the court, how much do we think the chief's influence last term was because he's the Chief Justice? And of course, that's not going to change. Or how much of it was that he happened to be truly the median vote among the nine? And maybe you have different answers to that based on even the three different cases you talked about. But I'm just curious if you have a sort of a take on that question.
That's a really interesting question, and it reminds me of, you know, I clerked back in 2002, 2003, and the court at that time, I believe, had been together without change for longer than any other court in modern history. And I recall someone saying, you know, every time when a new justice joins, it's a new court. And when you think about the amount and magnitude of change that the court has experienced over the last decade, it's really striking for an institution that is really known for its stability. So I think sort of all bets are off in terms of how the court will function, and how much of what we saw this term was because the chief was the median voter, and how much was because of how he exercised his authority as a chief. I think that's something that we'll all be watching to see how it unfolds in this new term. I think it'll be a very interesting thing to watch.
Yeah.
So, Allison, I mean, you began by saying, you know, you were an honorary Texan. I think of you as an actual Texan, but actually an honorary kind of colleague of ours here at Stanford, because you've done several of these talks with us over the years. I was asked to talk in the first round about the case that comes to be known as Bostick against Clayton County, which actually began as 3 separate cases at the Supreme Court. 2 of which involved the question, the Bostick case and a case called Altitude Express against Zarda, where we represented Mr. Zarda. 2 of those cases involved the question whether the language in Title VII of the Civil Rights Act of 1964, which prohibits discrimination in employment because of ... an individual's sex, covers discriminating against someone for being gay, lesbian, or bisexual. And the third of the cases, a case that began as EEOC against Harris Funeral Home, involved the question whether that language that prohibits discrimination because of sex covers discriminating against somebody for being transgender. The cases arrived at the Supreme Court and were consolidated. The 2 cases involving gay men were consolidated, and they were set for argument on the same day as the case involving a transgender woman. The first thing to notice about the cases is that the Supreme Court held in favor of the employees by a vote of 6-3 in all of the cases. So this was not a 5-4 case, it was a 6-3 case. And the opinion, which was assigned by the Chief Justice because he was in the majority, and this is actually the first case in which he's voted in favor of an LGBT plaintiff at the Supreme Court, the Chief Justice assigned the opinion, and he assigned the opinion to Justice Neil Gorsuch. And so that, I think, shaped in some really interesting ways the opinion itself. Because Justice Gorsuch is a textualist. And so there were a number of different kinds of arguments as to why the Supreme Court should rule in favor of the employees. There was an argument based on the Supreme Court's stereotype cases, where the court had held that sex-based stereotypes can violate Title VII. And obviously it's a stereotype, a normative stereotype, that men should be attracted to women and women should be attracted to men. And so you could have seen the case as a stereotype case. I think if it had been a case where Justice Ginsburg was writing the opinion, she might well have spent some time on stereotypes. It was also a case where there were precedents that people could turn to, most obviously Loving against Virginia, which had said it's race discrimination to treat interracial couples differently than same-race couples. And you could see that argument carrying over to say it's sex discrimination to treat same-sex couples differently from different sex couples. And yet, because Justice Gorsuch was assigned the opinion, it was the textual arguments that won the day. And the text arguments were that you couldn't talk about someone's sexual orientation without knowing their sex. You couldn't talk about someone being transgender without knowing what sex the person had been assigned at birth and what sex the person now identified with. So it was a very strong textual argument, and that's what Justice Gorsuch's opinion for the court ultimately did. So I want to now make a couple of observations about the case beyond that. The first is it really rejected the idea of some original public meaning of the statute in a way. Justice Kavanaugh's dissent was all about that, saying, and I think he was correct as a descriptive matter, that in 1964, no one would have thought that Title VII protected LGBT workers from discrimination. It was also not a consequentialist opinion of the kind that the more pragmatic justices would talk about, because at the oral argument, for example, Justice Gorsuch had asked, well, shouldn't we leave it to Congress to decide this issue? Because the consequences of deciding the issue and the potential social dislocation, shouldn't we take that into account? And the court basically said, that's not our job either. And so it was, in that sense, a kind of apotheosis of textual arguments at the court. The second point I'll make, though, about the consequences is, of course, there are a number of other federal statutes and state statutes that use the word sex. And because this opinion was so much based on what the word sex means, as opposed to what the general commitments of Title VII were or the like, we can expect that all of those statutes should also be interpreted in the same way. And Justice Alito, in the principal dissent, gave us a long laundry list of the other statutes that might be affected. The third point I want to make is a point about how this interpretation of Title VII will line up against another group of cases that the court has, and I think Jeff is going to talk about last term's decision in Morrissey Baru here. But one of the real questions is, what do you do when there's an anti-discrimination law that requires people not to discriminate on a ground that their religion tells them they should discriminate on? The Supreme Court has punted on this issue a couple of times, most notably in the Masterpiece Cake Shop case, which was a case from Colorado in which Colorado had a law that said you couldn't discriminate in a public accommodation on the basis of a long laundry list of characteristics, among them both sex and expressly sexual orientation. What do you do with a baker who says, my religion tells me I can't bake a wedding cake for a same-sex couple, even though, of course, he bakes wedding cakes for opposite-sex couples? And that's an issue that the court deliberately left open in Bostick, but it's an issue that the court had answered with regard to race many years ago in the Newman against Piggy Park case. So it'll be interesting to see how the court deals with that issue. The last thing I'll say is that it will be interesting to see whether the textualism that the court relied on in the Bostick case carries over to questions about what counts as race discrimination, an issue that's going to come back to the Supreme Court, I think, fairly soon in some of the cases that are challenging race-conscious affirmative action plans, most notably the case that was just argued about 2 weeks ago involving admissions to Harvard College. So a really interesting decision, a sign that the court takes its textualism seriously, and a decision that's going to have a series of rippling out consequences.
Pam, if I can ask you a question. You know, I think it was Justice Kagan who said several years ago, you know, we're all textualists now, and yet you had between the majority and particularly Justice Alito's dissent, it seemed like a real contest over what textualism is, what it means. Do you see that really sort of ferocious exchange between the majority and the dissent on textualism in particular? Do you see that as kind of opening up a new front in terms of textualism, what it is, or do you think it's kind of more of a one-off?
So I actually think you've put your finger on something very important, which is saying we look at the text and saying we're all textualists now doesn't tell you exactly how to think about the text. This is something we talk about a lot in the clinic with our students, the difference between justifications and reasons. And a lot of times justices will go to a dictionary and say, see, this is what the dictionary says the word means, therefore the following holding follows. And of course, they didn't start by saying, let's look in the dictionary and see what the dictionary did. They start with their priors, which come from worldviews and the like. And then, you know, the text can be somewhat plastic. I mean, there's some words that you might think they're obvious what they mean, but the court has never treated them that way. So the justices all say they're textualists, but when the First Amendment says Congress shall make no law, you know, abridging the freedom of speech, none of them, since Hugo Black maybe, think no law means absolutely not a single law of any kind. They all have a series of laws where they are going to say that's okay. So the text, you know, is something they have to look at, but there are a lot of ways of doing it. And I actually thought there that Justice Kavanaugh's dissent was in some ways a more interesting one, because he said, look, let's ask, what did the people who enacted Title VII, what would they have said if you had said to them that they don't mean to encompass sexual orientation within sex? And he didn't ask that question at oral argument. Indeed, in the two cases put together, he only asked one question. But my answer to that would have been, had they understood that the word's implications were that it would cover gay people, I have no doubt they would have written an exclusion into the statute, but they didn't write that exclusion in, so you can't. More profoundly, I think, in your question is, you know, once everybody says they're a textualist, there are going to be fissures among them as to what text means. In the same way that, you know, originalism started out as being one thing. You know, if you look at the Ed Meese form of originalism, it was original intention, and then it moved to original public meaning, and then the question was, you know, whose original public meaning? And so you now have competing originalisms out to, if you want to push it absolutely as far as it can go, Jack Balkin's originalism that says, you know, Roe is an originalist decision. So I think one of the interesting things that's going to happen as you get more conservatives onto the court is they're going to be less of a unified block, both in their methodology, because, you know, Justice Thomas says he's very much an originalist. I don't think of Justice Alito as an originalist at all. And there are varying kind of gradations among them. And so it'll be very interesting to see whether you end up with a single kind of unified method leading to unified results, or you often see some disagreement among them. I hope that kind of answered the question. It's a great question to try and figure out, well, now that we're all textualists, how can it be that every case isn't 9-0? And the answer is because people read the text differently.
All right. Well, I'm going to pick up in a sense where Pam left off and talk about the Morrissey Baru case she mentioned, and more generally the court's religious liberty decisions last term, and the coming clash between religious liberty and LGBT rights this term. To start with the case last term, Morrissey-Beru, the Supreme Court held a handful of years ago, following on some lower court jurisprudence that had developed over several decades, that there's something called the ministerial exception under the First Amendment. And what that exception is a constitutional carve-out to employment discrimination statutes like Title VII and the ADA and the ADEA and the like, that says that religious organizations are effectively immune from the anti-discrimination mandate of those statutes with respect to certain religious leaders, like sort of quintessentially at least, members of the clergy. And so in a case in 2012 called Hosanna Tabor, the Supreme Court held that a ordained minister who taught elementary school in a Lutheran private school was covered by the ministerial exception and therefore could not bring an anti-discrimination lawsuit when she was fired from her employer. And so the cases this term sort of raise a next question after Hosanna Tabor. Staying in religious schools, the question in front of the court was what about lay teachers in religious schools? So in other words, teachers who are not formally ordained ministers or have no formal religious title, but they are teachers in religious schools. And in this case, elementary school teachers who teach a general curriculum that includes, importantly, a module on religion, typically each day, just alongside math and science and the rest. So these are two fifth grade teachers who were in the Los Angeles area who taught in Catholic schools. And I turned out to represent them in the Supreme Court, arguing that they ought to be able to bring an ADA and ADEA lawsuit, respectively, against their employers. And the court held 7-2 that they could not bring that lawsuit, that they were also covered by the ministerial exception. And what's interesting is that holding itself was an extension of where the lower courts had gone. Before the Supreme Court took and decided this case, the general rule in the lower courts over decades had been that if somebody was formally ordained in some way or another, or had special training at least, that those people were covered by the ministerial exception in schools, but the lay teachers were not covered. But the Supreme Court disagreed with the lower court consensus and held, as I said, 7-2, with only Justices Ginsburg and Sotomayor dissenting, that the ministerial exception applied under these circumstances. And what the court said is, we don't want to get too hung up on titles or other formalities, because among other things, we could then disadvantage certain religions that aren't so hierarchical as, for example, the Catholic Church is. And so we're going to look more to sort of just the nature of the duties and what the person does. And under that test, the teachers in my cases were not meaningfully different than the teacher in Hosanna Tabor. So this holding raises two big important questions going forward, I think. And I think it's fair to say that one consequence of the relatively narrow decision the court issued, which just moved from Hosanna Tabor to teachers who teach religion in Catholic schools, or in religious schools, that is that the court left a lot unanswered in two big buckets. The first is what other kinds of workers or employees are covered by the ministerial exception, and so we can just start in schools. What about a teacher who teaches science or math or some other what we might think of as a secular subject, but of course does it in a religious environment and is perhaps told to infuse religious concepts and themes into his or her teaching. And then you could look at other people in the school, like coaches and principals and maybe even other folks in the school. And then outside of school, we could also ask, what about people like nurses in Catholic hospitals, or people who work at religious publishing houses, even lawyers who may be in-house counsel for religious organizations or churches. All of them would probably be said by their employers to help carry out important religious functions. And so even if they don't have formal titles, the question will perhaps arrive at the court in coming years, whether all those other sorts of people are covered by the ministerial exception, thereby, of course, stripping them of anti-discrimination protections that everybody else in the country has. And then that leads to the second question, which is what kind of claims are covered by the ministerial exception? The court so far has heard cases only involving hiring and firing under the anti-discrimination laws. But the court may have to answer in coming years questions like, what about other sorts of claims under anti-discrimination laws, like sexual harassment claims? And then what about just other forms of employment law claims, like wage and hour cases? Many of the old cases I mentioned a moment ago involving lay teachers involve things like head of household pay policies in religious schools, where men earned 50% more than women because they were thought under the religious principles of that church that men were the head of the household and therefore deserved more pay. And so it's an unequal pay case covered by the ministerial exception. So it's in a sense a problem, an issue that's been around a while, but now that we have a court that is much more energetic about religious liberty protections, we're going to have to watch how expansively the court interprets this doctrine. And that leads to the other case I'll mention quickly this term, another clash between religious liberty claim on the one hand and an anti-discrimination law or principle on the other hand. And this case arises out of the foster care program in the city of Philadelphia, where the city contracts out with private organizations various aspects of the foster care program, and in particular in this case, finding parents and getting them certified to be foster parents. And among the 24 or so organizations that the city works with are some religious organizations, and most notably Catholic Social Services. And in the ordinary contract with foster care agencies, the city insists on an anti-discrimination rule that prohibits, among other things, discrimination against LGBT individuals. The city found out, however, that the Catholic Social Services was not abiding, or was not willing to abide by that rule. And after some negotiations, the parties ended up at loggerheads. And so the city canceled the contract with Catholic Social Services because it was insisting on being able to carry out the foster care program while refusing to serve any same-sex couples who wanted to be foster parents. Resulted in a lawsuit where the city prevailed in both the lower courts, the district court and the Third Circuit, on the ground that under a longstanding Supreme Court precedent known as Employment Division versus Smith, the city rule could be applied against Catholic Social Services because it was a rule that applied to everybody. As the court has put it, it was a neutral and generally applicable rule. So it was not targeting religion specifically, but rather a rule that applied across the board. And under the Smith decision, religious organizations do not get, or individuals for that matter, do not get special carve-outs to generally applicable rules. And the court has now taken this case, and a featured argument in the brief for Catholic Social Services is that the court should overrule Smith because it's insufficiently protective of religious liberty. That would be obviously a dramatic thing. I'll talk later about Starry Decisis, but just for now, I'll say that this opinion itself, Smith, is a sort of bedrock religious liberty case over the last several decades, written by Justice Scalia. But several conservative justices have suggested they think that Smith is actually wrong. And so we'll see what the court does with that argument to overrule this precedent. But perhaps because overruling is always a big deal, there are two alternative arguments from each side in the case as well. So that the off-ramp that's being offered to the court by Catholic Social Services and by the Trump administration that has filed on their side is that the city of Philadelphia was hostile in its dealings with Catholic Social Services. And actually, even though its policy is facially neutral, it has religious hostility behind it. And so therefore, kind of like the way the court took the easy way, I shouldn't say the easy way out, but they took a narrower way out in the Masterpiece Cake Shop case on a similar ground. A way the court could avoid the Smith question would be to say that the city's actions transgressed just the ordinary requirement that religious organizations be treated with neutrality and respect. On the other hand, our clinic represents private respondents in the case that work with foster parents and foster kids. And one of the arguments we're making along with the city is that there's another reason you don't get to Smith, although this would result in an affirmance, which is that this is a special case because it involves government contracting, not just ordinary regulation. And we make an argument that the court, whatever you think of Smith in general, when it comes to forcing rules upon religious people or religious organizations, it's a different setting when what you have is religious organizations reaching out to say, we want to participate in the program, we want to participate in this government program, but we want to do it on our own terms. And we say that is not allowed, just as the court has refused to let religious organizations or others dictate their own terms in other settings of government contracting. So that's the Fulton case. It'll be a big one to watch. And if you're interested in it, it's going to be argued the day after the election. So an interesting day on the calendar, perhaps.
So Jeff, I'll jump in and ask you a question about employment division versus Smith. You know, with another Justice Scalia opinion that was in the crosshairs, and the court granted review limited to the question of whether it should be overruled, and that was our v. Deference. I think a lot of people were really surprised, myself included, that the court pulled back at the last minute, and you know, I guess it's been described as death by 1,000 cuts, but did not overrule our. What's your sense of with employment division versus Smith, sort of the appetite of the court to really take it on in a serious way and perhaps overrule it?
Well, we'll see. In part to keep us on track, and in part because I'm involved in the case and may well be hearing a question like that over the speakerphone in May. I'm sorry, in November. You know, I'll be brief in my answer, but I think that we know from just recent writings of several conservative justices, and it might be 4 of them, all but the Chief Justice, that they have expressed misgivings about Smith. So at least 4 sitting justices have serious misgivings. But at the same time, I think everybody realizes that overruling precedent is a very big deal. And as you said, you had a court that didn't seem to like a precedent, but stopped short of overruling it. So I think that's also why the parties in this case are offering various off-ramps one way or the other. And there's a set of arguments in the briefs on the other side of the case from us that offer the court some ways to narrow Smith. And so certainly the court will probably take a look at those too.
All right.
So back to you, Allison.
All right, back to me. So I'm going to talk about some of the cases this term that dealt with sort of if you think about the attempt to rein in the power of regulatory agencies as the war on the administrative state. I think this term was sort of a series of rather disappointing engagements where, you know, both sides took the field, rattled their sabers, and departed sort of unsure whether they'd won, lost, or lived to litigate another day. Probably the biggest victory against the administrative state was the Sailor Law case, which involved the Consumer Financial Protection Bureau. And that decision encompasses 2 important holdings, which are sort of, some of us think about it as what the right hand gives, the left hand takes away. So first, the court ruled that Congress cannot insulate single director heads of agencies, cannot insulate those folks from removal by the president. But second, the court held that the statutory provision involved in the case that insulated the head of the CFPB was severable from the rest of the act that created the CFPB. So the framers of our Constitution granted the president broad executive removal power. Article 2, for example, vests the executive power in a single president who must take care that the laws be faithfully executed. In a 1935 case, kind of a flashback to law school for some of us, Humphrey's executor, the court held that Congress may grant for cause removal protection to a principal officer on a panel of purportedly neutral experts. In a 5-4 ruling, one of the stories of this term was how relatively few 5-4 rulings there were compared to other terms. But in one of the 5-4 rulings, the court held in Sailor law that Humphrey's executor does not extend to agencies headed by a single director. In our constitutional system, the majority explained the executive power belongs to the president, and that power generally includes the ability to supervise and remove the agents who wield executive power in his stead. The court went on to emphasize that not only agencies headed by a single director, but those that exercise substantial executive authority must be answerable to the president. And the court held that the CFPB flunked both tests. It was headed by a single director and it wielded enormous amounts of executive power, but the director was removable by the president only for cause. And the court held that that removal restriction was unconstitutional. And the court limited the rationale of Humphrey's executor to multi-member expert agencies that do not wield substantial executive power, such as the Federal Trade Commission as it existed when Humphrey's executor was decided in 1935. All right, so the challengers declare victory, break out the bubbly, not so fast. 3 of the 5 members of the majority who held that the removal restriction was unconstitutional joined the 4 dissenters to hold that the unconstitutional restriction was severable from the rest of the Dodd-Frank Act that created the CFPB. And so, you know, you might think that the court's remedy of severing the statutory provision that limited removal of the director for cause will likely mean that the agency can pretty much continue to operate without significant disruptions. And the court kind of continuing the theme of unanswered questions I think all of us have touched on today. The court didn't address the issue of practical importance in the case, which was whether a civil investigative demand issued by a director unconstitutionally insulated from removal, but later purportedly ratified by an acting director who was answerable to the president and accountable to the president, whether that's enforceable or not. And so the court, again, to continue the theme, remanded for the lower courts to address that question in the first instance. And the decision reminds me a little bit about those t-shirts you used to see. You know, my parents went to the Grand Canyon and all I got was this lousy t-shirt. You know, I feel like the petitioners in Sailor law probably feel like, you know, I successfully challenged my regulator, you know, an administrative agency that according to the Supreme Court wields enormous amounts of executive power, and all I got was this lousy severability ruling. So I think that's kind of a major theme, I think, in a lot of the cases that we're talking about, certainly in the administrative law context, is you sort of see what can look at first blush like a big impactful ruling. Again, what the court gives with one hand in terms of its ruling on the constitutionality of the provision of the agency or what have you, it sort of takes away with the left in terms of the remedy. And I think just to briefly mention one of the cases that I think everyone will be watching, which is the Texas versus California, the Affordable Care Act case, where I think severability will be a key issue in that case as well.
Well, you to some extent, you stole my question from me at the end, but there's another version of that question that maybe I'll ask instead, which is, you know, from the, and I know we have a lot of our students watching this. So from the perspective of the lawyers who bring these cases, if you think at the end of the day, the court's severability doctrine is likely to result in an opinion like Salem law, do you continue to litigate those cases? Do you tell your clients to litigate a case where at the end of the day, it's not going to make any difference to them? I mean, I think back to the court's decision in Sessions against Morales-Santana a couple of years ago, where it was the differential treatment of children born out of wedlock to American citizen fathers. They can't be treated differently than the citizens, you know, children born to citizen mothers. So we're just going to say none of you gets the benefit of this great law. I mean, what does severability do practically to, you know, to how you advise clients should you take this case up?
Pam, I think you put your finger on a huge issue, which is in these cases, you pretty much have individuals going up against their regulators, right? Their enforcers. Actually filed an amicus brief today in a case, kind of a follow-on from the Lucia case, which involves someone who's kind of in the middle of an enforcement proceeding, and the question there is whether district courts have jurisdiction to go ahead and resolve the constitutional separation of powers challenges, or whether she has to, you know, continue litigating that issue before the very agency whose constitutionality she's questioning. So I think it's a big ask for people to come up against their regulator, and when you think at the end of it, you know, it's kind of a Pyrrhic victory for you in terms of what the future looks like for you and your own life and livelihood. I think it's a big ask. So I think no question that's something that anyone bringing a challenge to their regulator would think long and hard about before taking that step and taking that on.
Yeah. So I am going to discuss one case from last term and then some implications for this term. The case from last term I'm going to discuss is a case called Chiafalo against Washington. And it involves an issue that it's good the Supreme Court resolved when they did. And one of the interesting things was when the Supreme Court had to go into hibernation the way the rest of us did because of the COVID crisis, they had 2 sittings left. Instead of hearing all of the cases from those 2 sittings, when they set their special May sitting, they picked which cases to hear. And I think they picked ones where they felt it was kind of urgent to get the thing decided now rather than later. And then they picked one case to have as their first case being argued over the internet, you know, as a telephone conference call. I think they picked a case where they didn't think they cared at all about their result, just to make sure that they could get the telephones to work and the like. And I don't know whether that was the case in which they learned that justices should not flush the toilet while on the bench. But in any event, Chiafalo was one of those cases that the court needed to answer, because the case involved the question whether states can bind their electors in the Electoral College to vote for the candidate that the elector said he or she was going to vote for ahead of time. So there were actually 2 cases, one from Colorado and one from Washington, that involved electors in the 2016 election who had been pledged to Hillary Clinton, but who then didn't cast their votes for Hillary Clinton in a somewhat quixotic attempt to encourage Republican electors not to cast their votes for Donald Trump and thereby deny Donald Trump an Electoral College majority. If you can only read one opinion from last term for just sheer enjoyment, I think it's fair to say that Justice Kagan's opinion for the court here is one of the most enjoyable opinions I've ever read, with references to Hamilton the musical and the sorry sad end in Weehawken, New Jersey of Alexander Hamilton, because as you know, everything's legal in New Jersey. Essentially what Justice Kagan said is the states have the power to bind their electors and to replace those electors if it looks as if the elector is not going to follow his or her pledge, and actually to penalize electors who try and do so. The reason this is an interesting case in part also is it's a fascinating romp through American history, and the fact that the electors have never performed the role that the framers thought they were going to perform, of being kind of wise people who sort of think about which candidate to vote for, because political parties arose almost immediately after the framing of the Constitution. And because the political parties arose, it seemed that the electors were always going to be pledged. So it's an important case. I will note that it doesn't say electors have to vote the way they're pledged. It simply says states can force them to do that. And there are, in this upcoming election, for example, some swing states, Pennsylvania being the largest of them, that have no law on the books requiring electors to vote the way they pledge to vote. So an interesting case, an important case in some ways, because it gets rid of what some people call the faithless elector problem. Those are the people who think it's a bad idea to let these randomly selected people vote their consciences. And so, or the Hamiltonian elector, if you want to think of them as people who are supposed to think after they've pledged about whether they still support the candidate. Obviously, you're going to see a lot of election cases going up to the Supreme Court this year, and I think they can be divided essentially into three categories. One are cases that don't really have anything to do with our present situation, but have to do with laws of general applicability that have been attacked. I think probably the leading case here I would expect to go up to the Supreme Court in the next couple of months. And one thing we should just note for all of you in the audience is the Supreme Court issued an order extending the time people have to petition for certiorari now to, I think it's 150 days. And that means that, you know, you have close to 6 months to decide, over 5 months to decide whether to petition for cert. And so I think there are a lot of decisions that have happened over the summer and the like that aren't going to go up to the court until after the election. So the biggest case, I think, along those lines involves Florida's restoration of voting rights to former offenders, and whether Florida can condition restoration of voting rights on people paying court fees. That's an issue that divided the judges who sat on it en banc in the 11th Circuit 6-4, and it will be very interesting to see what happens in that case. There are some other cases along the same lines. Then there's a category of cases that are often referred to as the shadow docket cases, because these are cases that go up to the court seeking stays of lower court decisions, and part of the reason for seeking a stay rather than just going straight to asking for certiorari and plenary review is that you think by the time the court can get through that whole process, there's no point to it anymore. The election that you are concerned about is over, or the like. And so there are going to be some of these cases that are COVID related, either when states make changes to their election laws in order to respond to COVID, and those changes are challenged as being too late in the process, or cases where states refuse to make changes to their laws because of COVID, and somebody is seeking to force them to make those changes on the grounds that otherwise people are being denied the right to vote. So there are a series of cases that are going to be COVID related like that. And then there are going to be a series of cases that are the ordinary kind of election law case, which involve challenges to various statutes and how those statutes are being applied, or to changes that have been made in the statutes. And we've already seen several of those cases go up to the Supreme Court as well. And I anticipate a bunch more of them. And then there's a question which is lurking out there about what happens if this election goes off the rails in a whole lot of different ways. And some states try to appoint electors rather than having those electors selected based on the win of popular votes. Can the legislature claw back, and under what circumstances, and how can it claw back the power to appoint electors? I think most people would rather that the Supreme Court not have to decide the election. I think the Supreme Court's deciding of the election in 2000 was pretty controversial at the time. I think that controversy got kind of wiped out because 9/11 came along, and so people stopped thinking about what the Supreme Court had done in 2000. But the country is much more polarized now, and you have a president who's announced, in fact, that he wants the election to go to the Supreme Court, which is a very different kettle of fish, and that he thinks it's really important to get another justice appointed onto the Supreme Court before the election so that that justice can rule on the election. So I think most people would rather that the election not be in the Supreme Court, and certainly would rather that the election not be decided in a way that looks as if the justices are voting along partisan lines, but it'll be anybody's guess what actually happens. Your turn, Jeff. But you have to unmute yourself first. No, you still have to unmute yourself.
I know. Sorry. I knew somebody had to screw things up. That's what I'm here for. Okay. So I'm going to do one last module, and then that'll lead us into the Q&A period, which we want to make sure we have time for. And the module that I'm going to do right now is, I think I'm going to call it Starry, Decisis, and Louisiana. And the reason why I'm adding the state to the end of that is it just so happened that the two cases the court heard last term that most directly involved Starry Decisis were both from Louisiana. And as sort of fate would have it, I was involved in both cases. One is Ramos versus Louisiana, which was a clinic case. And the second was a case called June Medical, which was a case about abortion rights that I was also involved in. And I'll tell you what happened in those cases. And of course, Starry Decisis is one of the many things that are on people's minds right now with the new appointment potentially, well, obviously in the works. So I'll start with Ramos, which is really just kind of going in order of the way the court dealt with them. Ramos is a case argued on the very first day of last term. And it dealt with a Louisiana law dating back to 1898. That allowed juries to convict people of crimes, anything short of capital murder, by a non-unanimous vote. Under longstanding Louisiana law, it was enough to have 10 out of the 12 justices agreeing that the defendant was guilty. And that was challenged in Ramos as a violation of the defendants, of criminal defendants' Sixth Amendment right to jury trial as that applies against the states. And so the good news for the challenger in Ramos was that there was, in a sense, precedent supporting that argument because the court had said many times over the years the Sixth Amendment jury trial right requires the unanimous verdict. And the court had also said many times over the years that whatever the provision of the Bill of Rights means as applied to the federal government, it has to apply to the states the same way. So what could be the problem? Well, the problem was a 1972 case called Apodaca versus Oregon, involving the only other state that had a non-unanimous jury system, where the court said that this was constitutional. And Apodaca was a case involving a splintered vote where 4 justices said, we don't think the Sixth Amendment requires unanimity. The other 5 other justices said, we think it requires unanimity and it applies to the states. And one justice, Justice Powell, had said, I agree it requires unanimity, but I don't think it applies to the states. And so what to do with this sort of mess of an opinion that had a bottom line to it, but not any coherent reasoning. And what the court did in Ramos was it overruled Apodaca by a 6-3 vote. This was another opinion by Justice Gorsuch. And I'll just note parenthetically that for all the conversation about how influential the Chief Justice was last term, Justice Gorsuch, I think, was also quite influential in terms of his voting and opinion writing, and has been ever since he's been on the court. I think he's been the decisive vote in 5-4 cases, actually just as often as the Chief has since he's been on the court. And Justice Gorsuch said that, look, the common law in the Sixth Amendment has always been understood to require unanimity, and we've always applied things equally to the states, at least always in recent decades. And this is what perhaps the most interesting thing about Justice Gorsuch's opinion, he said, and because Louisiana's law is tainted by racially discriminatory origins, we think that tilts the balance in terms of overruling the past precedent. The 1898 law in Louisiana had been passed as part of the same constitutional convention as the grandfather clause and other features of Jim Crow, where actually the organizers of the convention had said that the purpose of the voting rules and others there were designed to establish the supremacy of the white race in that state. And that was a little too much for the court to swallow, at least a majority of the court to swallow. The interesting thing, though, goes beyond, the interesting things go beyond Justice Gorsuch's opinion, though. There were several separate opinions in Ramos. One separate opinion was written by Justice Kavanaugh, who agreed with everything I've said so far, but also had a very robust section basically laying out his entire theory of stare decisis. And so, I can't rehearse it all for you here, but basically what Justice Kavanaugh said is, I think we have the power as a court to overrule past precedents when we think they are, quote, grievously wrong, unquote. And Justice Kavanaugh cited many decisions over the years, and some of them are, you might think of them as liberal, and some of them you might think of as conservative, where the court has overruled past precedent because it just decides it's so wrong, it should be wiped off the books. And some court watchers actually think, by looking into the sort of assignment pattern from the sitting in which Ramos was argued, which also included Bostick, where Justice Gorsuch wrote that opinion, that what might have happened in this case is that Justice Kavanaugh actually was originally assigned the opinion, but when he wrote this comprehensive theory of stare decisis, some of the more liberal members of the court were unwilling to sign on to it, and then perhaps the opinion shifted over to Justice Gorsuch. We don't know that, but it's just kind of an interesting, it's always fun to speculate. But in any event, Justice Kavanaugh lays out his theory. And then the dissent was equally interesting, perhaps more than anything else, for who dissented. This was one of the two cases Allison mentioned at the top where Chief Justice Roberts dissented, and he was joined by the author of the dissent, Justice Alito, and also Justice Kagan. And I think many people thought this was an opportunity that Justice Kagan was taking to show how seriously she takes stare decisis, because from some questions she asked at argument and just some other things that she's written, one may have really thought that she really would have disliked Louisiana's law and wanted to strike it down if she had a clean slate. But signing the dissent and siding with the chief on a stare decisis issue may well have been so important on its own terms that that's what carried the day for her. And that leads into the June medical case, which was argued later in the term. That actually turned out to be, I believe, the last argument inside the Supreme Court room before the pandemic hit. This case was argued in early March. And this arose really as a sequel to an earlier case the court heard 4 years ago called Holman's Health, which involved a law from the state of Texas that required all abortion providers to have what's called admitting privileges at a nearby hospital. So any doctor who's going to perform abortion at abortion clinic needed to have admitting privileges. And in some ways that sounds like a sensible law and a beneficial law. But what the evidence showed in the Holman's Health case, and what the Supreme Court ultimately ruled 5-3, I think, because Justice Scalia had passed away and hadn't been replaced, but a 5-3 vote, the court said, actually the law doesn't serve any meaningful purpose because abortion is so safe. And what it really is an attempt to make abortion clinics harder to run and staff. And in fact, I think about half the clinics in Texas had to close. And the court said, therefore, the law didn't serve any sufficient purpose and imposed an undue burden on the right of women to obtain a safe and legal abortion. So one might have thought that would be the end of the matter when it came to admitting privileges laws. But lo and behold, Louisiana, the neighboring state, kept its fight going after Holman's Health. Its law was in fact explicitly modeled after Texas's, but nevertheless, the Fifth Circuit held that the law was constitutional. Long story short, because even though it was identical to the Texas law, the Fifth Circuit panel thought that the district court had been wrong in thinking that the on-the-ground effects of the Louisiana law were as serious as the on-the-ground effects in Texas. And so the Supreme Court granted cert in that case and ruled 5-4 that Holman's Health did control and that the Louisiana law was unconstitutional, just like the Texas law. And the pivotal vote in June Medical was the Chief Justice, who wrote separately to say that I am voting this way because of stare decisis, and a very particular form of stare decisis, I think, which is when we've decided a precise issue before, an exact same kind of law, we don't want the lower courts deciding for themselves that maybe we would decide the case differently. So the Chief Justice, having been in the dissent in Holman's Health, was voted in a sense the other way in June Medical because the precedent of Holmes Health he thought deserved respect, not just from the Fifth Circuit, but from the US Supreme Court. The 4 justices who dissented were joined by Justice Kavanaugh, and they would have said that Holmes Health did not control. And that's sort of the other thing about stare decisis. It's not just whether the court is going to formally overrule precedent, but stare decisis could also be thought to involve, how much respect are you willing to give precedent, and how willing are you to distinguish it on a threadbare set of reasons. And what the 4 justices, this is perhaps my own perspective, but the 4 justices who dissented in June Medical would have distinguished the Louisiana situation from the Texas situation, and really set the stage for just kind of a never-ending cycle of litigation on these particular kind of laws, and who knows what else. So that's where we are on stare decisis in general, and abortion in particular, as we now head into this term and a new justice perhaps joining the court.
Thank you to all you, Allison and Pam and Jeff. That was extremely illuminating, except in one respect. I'm absolutely stunned, astonished, and appalled that there was no discussion of the very first case of the coming term. And they're all 3 wondering what is.
No, I assumed that at some point you would say, and now enough about you, let's talk about me, let's talk about my case.
I just did. Chaz, we're going to move to questions from you all now, but first a word from our sponsor, Chaz.
This is just an announcement to the audience members that if you would like to receive MCLE credit, please use the link that I just chatted and fill out that form so we know that you were here and we can get the credit to you.
So I'm going to turn over the gavel to 2 of our students. This session tonight was co-sponsored by 2 of the law school's largest student organizations and most pertinent to constitutional law, the Federalist Society and the American Constitution Society. And we so appreciate the presence of these 2 groups at the law school, because they both bring in a diverse set of speakers, and they also guarantee a kind of that there's going to be a discussion and dialogue across the polls. And so they are both co-sponsors of tonight's event, and accordingly we invited each of them to bring one of their leaders here to conduct the audience question and answer portion. So I now turn it over to them, and they will be fielding your questions and relaying them to the appropriate panelists.
Hi, everyone. Thank you very much to the panelists for a very enlightening discussion. As Professor McConnell said, David and I will be fielding questions in the chat. So someone just posted in the chat, how do we submit a question? Just drop it right in the chat and we'll relay it to the panelists. Professor Fisher got slightly ahead of us. David and I were talking about this off screen with his last module on stare decisis, because the question that, one of the first questions we were preparing to ask was about stare decisis, but considering that Professor Fisher gave a pretty detailed discussion of that, perhaps we can return to one of the matters discussed at the very beginning of the panel on administrative law. One of the questions that came in asked about what the panelists think about the future of Chevron deference, particularly in light of the likely upcoming confirmation of Judge Barrett.
So I'll jump in on that one. I think one of the interesting things about the decision upholding our deference, which I think most court watchers thought was low-hanging fruit in terms of that form of deference officially biting the dust. So the court pulled back from that, but the chief wrote separately to say that folks shouldn't see that decision as necessarily indicating what the court would do with respect to Chevron deference. I think a lot of watchers were kind of puzzled by that, because we sort of thought, well, our doesn't seem to have as much bite as Chevron. And so if our isn't, if ours going to stick around, it would seem like Chevron would too. My own view has been that we would not see Chevron overturned anytime soon. What we would see would be a series of cases where the court found that it didn't need to resort to Chevron because it found the statute at issue clear and unambiguous. And so you sort of get a Chevron, a death by 1,000 cuts in a similar way that you saw our deference go. So my own prediction, I'd be interested in my co-panelists. I'm not optimistic that it will be overruled. I just think we'll see a series of cases where the court will decide that it doesn't need to resort to it because it's going to find the language clear, plain, and unambiguous.
I think the thing I might add to that is that it's not just a matter of what the 9 justices think. It's also part of the court's interplay with the government that's at stake when it comes to Chevron. And one thing that's been notable the last few years when the current administration has filed briefs in the Supreme Court is they have been extremely hesitant, if not unwilling, to make robust Chevron arguments to the justices. And so one thing to watch, I think, is going to be, depending on how the election comes out, if you have a new Solicitor General's office, it's possible that a different office could have a different attitude and set up, perhaps, more dramatic clashes of administrative law principles with at least some of the justices on the court. And so I think it's just a good reminder that it's not just the justices themselves that do everything, it's that they're also reacting to the outside world. And so that'll be, I think, an important part of the question that was asked.
Great. Now for our next question. So considering June Medical and Ramos together, what is the current state of stare decisis on the court? Sorry about that. Yeah, so what do you make of that? Oh, sorry, I got the question confused. Sorry about that. So in the 2 cases this term, Ramos and Espinosa, the justices spent some time reflecting on the discriminatory origins of the state laws. What do you make of that? Should it matter? And are there other cases that follow this pattern?
So I'll take a first crack at that. I was struck in both cases by the fact that there was criticism from the dissenters in each case that you shouldn't talk about the racial origins of a law. But this is going on at the same time that I think the court is moving more and more towards the requirement that you have to show a discriminatory purpose to get a law struck down as being racially discriminatory. And that would especially be true for the justices who don't really believe in disparate impact. And so that puts litigants, I think, in this odd position where you have to claim, purposeful racial discrimination to win the case, but you get criticized if you press a racial discrimination argument. And I think that kind of double bind will play out in a number of areas of law, everything from voting rights to, kind of orthodox race discrimination cases, which neither Espinosa, which was a First Amendment free exercise case, or Ramos was about directly.
So there's another question in the chat from earlier, actually about habeas corpus. One of the questioners asks whether the Justice Alito's opinion in Thurassingham upholding a very limited form of habeas review for the decisions of immigration officers. The questioner asks how that interacts with the Supreme Court's earlier holding in Boumediene, and if it's essentially overruling it or if it's simply distinguishing it, and what the relationship between those two cases on habeas is.
I mean, I'll just take a first order crack at it, which is Boumediene, although it's in a formal sense, it's a case about habeas, is a case about the war on terror. And so it's a case about the question of kind of the extraordinary way in which the United States government tried to deal with the folks in Guantanamo. Whereas Thurassingham is really a case about a pretty standard set of immigration style cases. And the question, I mean, if I had to say what case did Thurassingham remind me most of, it reminded me most of the Bivens case about the cross-border shootings, which is this question of what exactly is the kind of legal status of people close to the border in some ways. I mean, they're both cases essentially about questions about just how much process we have to give people, you know, before they're removed from the country, which strikes me as, I'm not sure you can read across those cases necessarily, because I think they're really dealing with a very different context.
Yeah, just a couple quick thoughts. You know, I think one interesting thing about the court's habeas jurisprudence over the years is that it's almost like this is an area where the court gives Chevron deference to itself. The court really has used a lot of its own sort of, if I can use this word, sort of policy-making power to shape the contours of habeas law. And Thurassingham was of a piece of a court that's always been willing to rethink and to reimagine what the boundaries of habeas law are. Sometimes in years past to vastly expand the circumstances under which the writ could be granted, and in more recent years to contract it. You know, this court, this term actually, there's another habeas case involving whether Ramos is retroactive for the thousands of people in prisons in Louisiana and Oregon who were convicted by non-unanimous verdicts. And there's another set of arguments in that case, some of which are rather conventional, but there's some more imaginative arguments in front of the justices there too. And so it'd be another case to watch as to whether the justices, you know, what they do there.
Great. So one of our attendees was wondering to what extent the justices should look to presidential statements to figure out motives behind actions.
Are you asking that as a descriptive matter or as a normative matter?
I probably descriptive.
The court doesn't seem to care very much. That's the descriptive answer.
Thank you, Professor Carlin.
One of the attendees asks a question about the Alien Tort Statute, asking if there's any chance for respondents in Nestle v. Doe after the Supreme Court's decision in Jessner.
Well, I guess I ought to start since I was a lawyer who lost Jessner. Jessner was a case where the court held that the Alien Tort Statute, which allows non-citizens to bring suit in US courts for violations of the law of nations, did not allow suits against foreign corporations. And it was a bit of a surprise holding because the way the case had been briefed and argued to the court was a little bit broader than that I think both parties were making sets of arguments about corporations in general. And what the court did is decided the case very narrowly. So simply for that reason, I would say it's still a case where the outcome, I think, is not preordained, because if the court had already decided that US corporations should be treated no differently than foreign corporations for purposes of lawsuits like that, they would have said so, I believe, in Jessner. And so I think there's still the possibility that the court would reach a different result, and it wouldn't be crazy for the court to do so. I mean, the thing the court has said in these types of cases is the court does not want United States courts to be sort of the courts for the world, and problems that are really arising out of things beyond our borders, and sometimes even dealing with the prerogatives of other sovereign nations, shouldn't be litigated in our courts. And so that's an easier concept to understand when you're talking about a case involving, as Jesner was, a bank in the Middle East that's very, very close with various foreign governments. If you have just an ordinary U.S. corporation as the defendant, you might think that those concerns play out differently. So we'll see how it goes.
Great. And we had another attendee wondering whether any of you would care to address the court's treatment of Native Americans, either in this past term or going forward.
Well, I'll say something quickly. This is another area where I think the changing membership on the court matters, and Justice Gorsuch has in a sense shifted the dialogue at the court in a way. I think Allison mentioned earlier, this was the other case last term that the Chief Justice dissented in, a case from Oklahoma involving jurisdiction for prosecuting crimes. And Justice Gorsuch joined, I believe, the 4 Democratic appointees to hold that criminal prosecution could not be brought because a big swath of Oklahoma was still effectively Indian country, and it had not been changed by any congressional decision over the century and a half since. And so I think there are some people who believe and who have noticed that perhaps Native Americans and tribes in general who are coming to the court, who've had a very rough time of it over the years, just if you look at wins and losses, might have a more receptive court right now. And I think that's about as much as we can say in general terms.
Another attendee is asking about the extent to which, or the principle that, the court should not intervene on voting procedures or voting related issues so close to the eve of an election. This was a rationale that emerged recently, I believe, in Wisconsin, and there's also a suit pending before the Supreme Court, or not a suit, excuse me, a request for an emergency stay pending for the Supreme Court on a recent decision out of the Pennsylvania Supreme Court. So I suppose the question for the panelists is, to what extent is the Supreme Court going to stay its hand and try to avoid radically changing state voting procedures as we get closer to the election?
Well, some of that depends on what's being changed and by whom. So for example, the Supreme Court had up in front of it a case from Rhode Island on an emergency stay, where Rhode Island had agreed in a consent judgment to change its laws, and a majority of the Supreme Court was not going to intervene there. Whereas in the Wisconsin case, where it was a federal judge changing the laws, it intervened to stop some of those changes, but not others of the changes. And so the answer to that is, it's a really hard question to figure out exactly where the court will come down, because some of it will depend on the extent to which the court thinks that the changes that were made are justified by the circumstances in front of them. Some of it's going to depend on who the parties are in front of the Supreme Court. That is, if a state comes up to the Supreme Court and says, we're happy with our law, the way we changed it, we're happy with the change, as the Rhode Island, the case from Rhode Island did, the court's less likely to do something about that. And even if the court doesn't want to change the rules ahead of time, there are going to be a bunch of cases that involve challenges that don't involve changes to the law at all. And there, the Supreme Court's calculus is likely to be a little bit different.
Great. So another attendees wondering whether the National Popular Vote Interstate Compact would be constitutional. That's the effort to collectively represent an absolute majority of votes in the Electoral College.
I mean, so the question there is really a question of, does the Interstate Compact, which would, essentially what it does, for those of you who don't know about it, is it's a bunch of states that pass a law that says if enough states to have 270 electoral votes sign on to saying they will give their electoral votes to whichever candidate receives the most popular votes nationwide, regardless whether that candidate receives the most votes in our state, we'll give our electoral votes to that candidate. So for example, that would have meant in the 2004 election, where George W. Bush received more votes than John Kerry, California would have cast its electoral votes for George Bush, even though John Kerry beat him by, you know, a fair amount in California. And it would have meant in 2016 that Texas would have cast its electoral votes for Hillary Clinton rather than for Donald Trump, even though Donald Trump got many more votes than Hillary Clinton in Texas. I think he beat her by like 9 or 10 percentage points. So the real question here, I think, is can the states do this without congressional approval? Because the Constitution suggests that states aren't supposed to make treaties between themselves. They're supposed to follow something called the Interstate Compact Clause, which says essentially Congress has to sign off on these. And it's anybody's guess what the Supreme Court would say about that.
And then I think a final question as we're getting closer to 6:30. A couple attendees in the chat asked about the current presenting technology that the court is using. I believe the panelists were discussing this before the event started properly. Do you think the court will continue providing live audio once the pandemic abates and they're able to meet again? And I suppose a supplementary question to that is the kind of eternal question about cameras in the courtroom and the extent to which this might be a stepping stone to cameras in the courtroom.
Well, I mean, I'll take a first crack and say, I think the reason that they use this kludgy telephone conference call technology instead of going to something like Zoom or, you know, Microsoft Meetings or one of those is they didn't even want to let the nose into the tent of having any televised arguments. They already release the tapes of the oral arguments on the Friday of oral argument week. So it's not that big a difference to have the live, you know, the live broadcasting that they did this time around. I don't know whether they'll keep the live broadcasting, but that's why they didn't go to something that was televised, because once they could show that it's easy for them to televise, it's much harder for them to argue, we don't want to do it. I mean, that's just my hypothesis, but, you know.
I agree with Pam that cameras in the courtroom or even Zoom, if that's what it would record, are not coming anytime soon to the court. I think it's a definitely more interesting question, though, whether the live streaming will become something that's expected. And it may well turn on questions about just whether there's a different set of issues about live streaming out of the courtroom as opposed to live streaming an audio feed out of the sort of highly regulated conference call that the court was able to put together that format in May. So I don't know the answers to those questions, but I think it wouldn't surprise me too much if it's logistically possible if something like live streaming continued.
Yeah, I mean, the one thing just to say about that is that, you know, Jeff is making a really important point, which is it's impossible to disrupt the current live streaming because the only people who can dial into it are the justices, you know, who might flush or might not, and the lawyers, but there's nobody else on those calls. And I don't know whether Jeff or Allison, you were in the courtroom for any of the times people disrupted the courtroom, but they don't like that. The Supreme Court really does not like being disrupted. And the risk, if you live stream, of having a disruption, I think they may think is higher than if you release the tapes on a Friday, because who's going to like scream in the courtroom if it's going to be 4 days later before anybody hears them scream? You know, it's like if a tree falls in the forest and no one's there, does it make a noise? Was that a deep philosophical way of answering that question? Maybe not.
Well, it may not be deeply philosophical, but it is at the end of our time. So thank you, Christopher and David, for emceeing the questions and answers. Thank you to the audience for coming, and especially thank you to the three speakers for speaking. The next Con Law Center event is going to be on October 9th. That's right?
October 7th. October 7th.
October 7th. You know, what would